Hi, thank you for coming back from lunch. I hope you had a good one. And we're now moving to the second panel titled Children's Self-Determination in Crisis Situations. As you can see, we have a packed group, so we will do it. I'll do the introductions briefly, and then we'll have you one by one. I will not intervene, and we will be very strict with the time, so bear in mind. We start with Noah. Dr. Noah Levy is a postdoctoral fellow at the program here, Tali's program, the Child and Youth Rights Program at the Minerva Center of Human Rights. I'll not say it every time because we all know, right? Noah is researching children and youth focused migration in African contexts and is currently focusing on asylum seeking children and youth in Israel. She is working under the supervision of Tali, Professor Tali Gal, and Professor Laura Landi. Then we have Olga. Professor Olga Kazova Gurevich is an old friend, and also currently affiliated with Tali's program. She wrote extensively and importantly on international family law and international children's rights. Dr. Chaya Gershuni is a postdoc at the same program. She focuses on the rights of children and people with disabilities from the ultra-Orthodox community, the Haredi community. She leads a forum for researchers studying disability and health in the Haredi society at the Center of Disability Studies at the Hebrew University. Her current research examines the implementation of child participation theories among ill Haredi children. Then we have Professor Rona Shoz, also an old friend. Rona is a full professor at the Academic College of Law and Science in Israel, Merkaz האקדמי למשפט ולעסקים. And she's also a professor at Bar Ilan University Faculty of Law. Before moving to Israel in 1993, she was a lecturer in law at the London School of Economics. She has an MA in LLM from Cambridge and a PhD from the University of London. She has written extensively in areas of child law and private international law, with particular emphasis on the children's rights and international child abduction. In addition to numerous articles, she has published 2 books: a modern approach to the incidental question in conflict of laws in 1997, and the Hague Child Abduction Convention in 2013. In 2023, she received a grant from the Israel Science Foundation for a 4-year empirical research project on child abduction cases involving Israel. Last but not least, we have Roni Rotler. Roni is the Disability Program Director at the Equity, Diversity and Community Commission at Tel Aviv University. She holds a BA and MAs from Tel Aviv in law, and she also has a BA in philosophy from Tel Aviv University. Psychology, sorry. It's very small. She specializes in research on disability rights, clinical legal education, and therapeutic jurisprudence. Her doctoral dissertation, submitted to Bar Ilan University, Mazal Tov, examines systematic mechanisms for implementing disability rights and equality principles, particularly emphasizing legal capacity, child welfare, and parental rights of individuals with disabilities. Her scholarly work is informed by extensive experience in legal representation of parents in child welfare proceedings, synthesizing academic research with practical advocacy. And we will directly move to Dr. Noah Levy.
Okay, thank you.
Thank you for being with the time, Yala.
Okay, so thank you all for being here, especially after this wonderful lunch. And thank you for this conference, which I think is really important this time in our lives here in Israel and in the region. Migration regime and state mechanisms produced a charge encounter between non-citizen children and the desire of the state to keep the citizenship, to keep its autonomic control over citizenship. And it is expressed by the difficulty of countries in granting rights protection and proper institutional frameworks of care, education, and welfare to non-citizen children. In some countries, Upholding the principles of the CRC is perceived as countering state autonomy in deciding its boundary of citizenship. As Adi Ophir argues, repetitive demarcation of who belongs and who does not belong has become the nation-state's form of existence. Through the endless discussion of the definition of belonging and foreignness, and the physical, political, and social rejection of everything that is perceived as foreign, national belonging reaffirms itself. Thus, as some governments perceive these acts of inclusion and exclusion vital for their survival, the crisis in which non-citizen children live in is denied. In the eyes of these states, non-citizen children become non-children, rather than children whose rights are to be respected and protected. In this presentation, I will discuss preliminary findings and thoughts drawn from the discourse analysis of the review of the 5th and 6th combined periodic reports of Israel in the Committee on the Rights of the Child, focusing on asylum seekers, which was held in this last September, the 3rd and 4th in Geneva. The Convention on the Rights of the Child directly and indirectly addresses children without citizenship status, including asylum-seeking children. The CRC requires governments in numerous ways to establish a comprehensive framework of rights for children and youth in irregular migration situations, to take full responsibility for their welfare, safety, and physical and mental security, and to make sure that the entire scope of children's rights will not be contingent on formal citizenship status. In addition, the Convention stipulates that even in the absence of formal citizenship, governments must follow the guidelines of non-discrimination, the best interest of the child, participation, and development. So Article 22 of the Convention speaks directly on refugees and asylum seekers, basically saying that regardless of citizenship and regardless of state status, children are entitled to all the rights of children, regardless of their civil status. But it's not the only article that is relevant here, because many provisions in the Convention address common life situations faced by stateless children and asylum seekers. For instance, articles that refer to child abduction and trafficking in persons, articles that refer to child labor and exploitation, children who are removed from their homes, and children who are held in arbitrary detention. All of these articles speak to the living experience of asylum seekers in Israel. So there is really no question. You can look at the CRC, and the CRC can give you the guidelines of how to treat asylum-seeking children, if you wish to look at these guidelines. You know, at the morning when I came here and the YAB members were here and they were speaking from their phones, I said, I'm old. I need to update my technology. All right. So asylum-seeking children in Israel are at one of the worst situations that are imaginable and that happen in countries all over the world, Western countries, but not only Western countries. Israel is really doing a good job on that issue, with less than 0.5% of children recognized as refugees, and the constant and progressing denial of their basic rights. They are excluded from welfare and healthcare mechanisms that are available to the general population. And nowadays there is a high court case in regards to private health insurance, which actually denies children that are not from Eritrean, Sudanese, or Ukrainian descent the option of having health insurance. So now this issue is nowadays in discussion in the High Court. Last interesting development is that children with autism will be denied of therapy and treatment in preschools, in communication-focused preschools. So you will have one classroom with kids who have citizenship and will be treated, and asylum-seeking children which will not be treated for their difficulties. The absence of subsidized frameworks for children aged 0 to 3 leads to significant developmental harms due to unmonitored care facilities for early childhood in the asylum-seeking community. And in many cities, not all of them, but in many cities, asylum-seeking children are segregated from the Israeli children in the education systems. You would be surprised to know that the situation does not improve with age. Given the lack of opportunities for integration into Israeli society, the future of asylum-seeking children and youth, it's still this one. The future of asylum seekers in Israel remains dire. As they approach the age of 18, they realize that the temporary visa that they have cannot give them permits to join the military service. Now, I know what many of us think about the military service, but it is a strong path of inclusion into Israeli society. So they have no way of doing military service, national service. They cannot obtain driver's license. They cannot study professions that require state licensing, such as medicine, social work, nursing, accounting, and tuition fees in universities, such as this. Asylum seekers have to pay 125% because they are considered as foreign students. So now, that's the slide. Yeah. With the aspect, we're talking about children, and then I talked to you about what happens after the age of 18, but the absence of prospects prospect for the future is something that is deeply influential on children's lives. I mean, children who know that they have no future, have no incentive to go to school, to complete their education, and to dream, which is a basic right, I think, for children. So the aspect of prospects of their future as adults impacts their treatment and lived experience as children. Investing in education frequently appears to be reasonless, definitely when they see their older siblings who are educated, working in manual jobs, have no prospect for a better future. And these critiques and others were compiled in an alternative report submitted for the consideration of the Committee on the Rights of the Child in preparation for the review of the 5th and 6th combined periodic reports of Israel. So the committee, the chair of the Committee on the Rights of the Child, Professor Anne Skelton, has made 5 main critiques and inquiries in this regard. First of all, she asked how many children are actually being granted refugee status. She also asked what is the government doing in order to provide asylum-seeking children with a more stable status that will enable them to fit into society. Why do young asylum-seeking children suffer more from developmental harms in the child protection system? And a very important comment of her was that using parent status in order to decide on children eligibility for services is a violation of the Non-Discrimination Act, and thus is a violation of the convention itself. Throughout the whole 2 days of debate, this was the only time that somebody from the committee has said explicitly that Israel is violating the CRC. And I think that is important to note that. And another observation she made was about unaccompanied minors and how can they apply for asylum. So, the Israeli delegation's response was this, actually. Other than talking about unaccompanied children and the mechanism they have in order to apply for asylum, and saying that that there are no pending requests of unaccompanied children for asylum, the delegation remained silent about these issues. Perhaps as policies become more and more restrictive and state officials become more cynical about their responsibilities toward children in forced migration, there is no other option for the diplomatic arena but to remain silent. And now when I'm talking about cynicism, this is our Minister of Interior, Moshe Arbel, who arrived at the airport as thousands of asylum seekers leave the country to start over in Canada, to make sure that they are going on the planes and make sure that everything is working as properly. So, cynicism. The chair of the Committee on the Rights of the Child, in his opening statement, the Director General of the Ministry of Justice, Itamar Donenfeld, has required the committee's support in the face of October 7th and urged the committee to condemn Hamas and Hezbollah. He also implored the committee to avoid the politicization of children and childhood. How many minutes do we have? Just this. All right. We won't see a video from the debate, but I thought that in light of his request to not politicize children, I thought that we should take a look at the children who are seen and who are visible in the opening statements of both heads of delegation, which are Itamar Donenfeld, the Director General of the Ministry of Justice, and the Ambassador to the UN in Geneva, Daniel Meron. Children, Israeli children who are direct victims of October 7th. Israel's traumatized children from the October 7th massacre. Israeli children facing direct security threats during the war. Israeli and Gaza children as objects of the Israeli efforts to protect children. This means when they discussed, for instance, the efforts that the Israeli regime is doing in order to vaccinate against polio. So the children are just object of this remark, but it can highlight what Israel is doing for the children. Gaza's traumatized children by the Hamas, of course. Palestinian children as perpetrators and the descending age of Palestinian terrorists. And Gaza children as object of the Hamas brutality. So these are the children who are visible in who were visible in the opening statements of both heads of delegation. So when we're thinking about politicization of children and childhood, maybe this should be taken under account. While constantly reminding the committee that the delegation is addressing children in Israel, as opposed to children in the preoccupied territories, it remained silent regarding children who challenge the definitions of state responsibility and actively choose to disregard them in the diplomatic arena. As both heads of delegation required the committee to avoid the politicization of children, their own words exposed the political use of children by the delegation in what is said and mostly in what is not said. Thank you.
Dear colleagues, dear friends, dear Tali, dear Sharon, dear all, I'm incredibly happy and honored to be here and to be able to talk to you. The story of my appearance here is very long, but for me very exciting. But right now the topic is about completely different, although in a way related. So in my presentation, I'm going to address some of the aspects of my research project here at the Hebrew University of Jerusalem that is about child right to identity, which is protected by the UN Convention on the Rights of the Child and which is increasingly on the agenda nowadays. However, it will not be possible for sure to address all the aspects of the project in a 15-minute presentation. So I decided to limit myself to one of the aspects which, in my opinion, fits mostly in the general theme of our conference. So my main focus will be on the child right to national identity with regard to Russian-speaking repatriated children to Israel. So it works. The point is that the scale of immigration to Israel during the recent years was tremendous, particularly from the countries that were formerly part of the Soviet Union. Moreover, official statistics indicate significant increase of immigration from the particularly Ukraine and Russia, followed after the Russian invasion of Ukraine on 24th of February 2022. Thus, slightly more than 57,000 people immigrated to Israel only during the period from May 2022 until the end of that year, and overwhelming majority of them came from Russia, Ukraine, and Belarus. In the next 6 months, the first 6 months of next year, 2023, more than 29,000 immigrants arrived in, and close to 80% of them were from Russia only. In this regard, I have to specify that the vast majority of newcomers come to Israel under the so-called law of return. So actually it means that they don't immigrate but repatriate or come back home. In this, which is considered to be absolutely unique feature in worldwide migratory movement. In this respect, using words immigrant or immigration is not quite correct, but I would use it conventionally just for the convenience. No, of course, among those who arrived to Israel during recent time, there were children constituted a significant part, and most of them were not familiar with Israeli culture, or slightly familiar or not familiar at all. Most of them, overwhelming majority of them, didn't speak Hebrew and had never been to Israel before. So therefore, questions arise. Who are these repatriated children? How do they feel? Where do they belong? Do they perceive themselves as Russians, Ukrainian, Belarusians, as the case may be? Are they Israeli, Jewish, or both, or neither, or consider themselves as people of the world? Are they comfortable in Israel? And if not, why? And what could or should be done in order to make them feel more comfortable here, to make the process of the adjustment to life as in Israel more efficient and more pleasant? And all in all, what could be done to make them begin feeling more like Israeli than anything else? And if they face any national identity conflicts, what could or should be done in order to help them to reconcile these different identities or two identities, and to avoid an identity crisis and all the negative consequences that may follow. As for definition of identity or national identity, there is no definition anywhere, particularly in the UN Convention on the Rights of the Child, and there is no single answer to what is identity or what is national identity. The UN Convention on the Rights of the Child, which is actually the first international human rights treaty who expressly recognized the child right to identity, in Article 8 postule states that states parties undertake to respect the right of the child to preserve his or her identity, including nationality, name, and family relations as recognized by law without unlawful interference. That's it. It doesn't define the notion of identity, as you see. It doesn't define. It doesn't contain the excessive list of elements that constitute identity. It names just 3 elements. It means that we should therefore include into the concept of identity all other aspects like as ethnic, national, cultural, social, religious, gender, among others. There is no formal definition of national identity either, and in the academic literature, it is defined as part of social identity, as multidimensional construct, as a complex psychological concept that consists of numerous cognitive and emotional elements. So basically, it's about everything. Usually, people associate themselves with one nation and thus develop one national identity or single national identity. However, there is a variety of situations when people may feel belonging to 2 countries or to several countries and accordingly develop binational identity or multiple national identities. And it is particularly common occurrence in immigration cases, especially with children. When one identity relates to the host country and another one relates to the country of origin. This is clearly illustrated. I like this piece very much. This is clearly illustrated by the answer of an adolescent child who immigrated with parents from Israel to United States. He said, "I would consider myself an American." Well, that's funny because my name is Darren, and Darren is the American. Itzik is Israeli. My mom has never said the word Darren to me once. She only calls me Itzik. Close family and friends call me Itzik. When I'm with my American friends, I'm Darren. So there are 2 people. When I'm Darren, I am an American Jew. When I'm Itzik, I am an Israeli. So somehow children manage with all these problems. And fortunately, children immigrants, especially in early childhood, according to sociological studies, often demonstrate high levels of emotional, of psychological, educational, behavioral adjustment to the life in the new country. As for repatriation, oh my goodness! As for repatriation to Israel. Such little kids usually have a more solid Israeli background compared, for instance, with teenagers because they have a higher proficiency in Hebrew, a higher sense of Israeli identity, and more Israeli social network. For adolescent children, the process of adjustment to new environment, or in our case, Israeli environment, may be much more complicated as adolescence is a period which covers formative years for a child. And dependently on the circumstances when the child was moved to another country, the child may feel divided between 2 cultures, or he may not feel belonging to the host country culture. And if there is no support provided to such a child, the child may face very, very strong national identity challenges, and it may traumatize a child and even cause serious identity crisis. Here I will just the basic stuff is at the screen. So I will just highlight that for adolescent children, the situation is exacerbated by the fact that adolescence itself is a is not an easy, though very important period in child's life, which may define the whole future child's development. And it is usually described this period as adolescent crisis, which in fact, according to specialists, is an identity crisis. And the term identity crisis was used by psychologists, psychoanalysts, to describe the period of uncertainty and ambivalence of children during this age. This is when they first raise questions about such existential questions as who we are and why we are here in the world. So, not surprisingly, in immigration, when an adolescent child faces all these challenges related to need to adjust to a new culture, it may significantly worsen the adjustment to a new culture and create really national identity crisis for such a child, which will, as I said, may influence the whole child's life, because he had to cope not only with the adolescent crisis as such, but also plus to that, on the top of that, national identity crisis. Of course, it is important what was the age of the child when the child was moved to a new country. And as studies show, the younger the child, the easier it is for him or her to get adjusted. However, for adolescent children, it is often becomes absolutely, to quote sociologist, shocking experience, because they are placed usually with no Hebrew, to Hebrew school, to Hebrew class, and are supposed to manage somehow while listening to the teacher talking to the children. And this is the main problem. And my so far informal talks to some of the adolescent children prove my assumption that this is a solid stress and trauma. To come to my conclusion, I would say, I would dare to say that amongst numerous challenges that adolescent children, and first of all adolescent children, face after they arrive to Israel, is those related to Hebrew language studies and generally studies at school, and also I would dare to add, with almost no support, psychological or social support from community, from school, from state bodies or whoever they are. And these are areas where the state can really provide a lot of support to children and make their adaptation to life in Israel much less stressful and much more smooth. In my final stage of the research, I'm going to interview children, school children, mostly adolescent children, and we'll see whether the results will either confirm or deny my assumptions. Thank you so much.
Thank you. I apologize, but my English is not so well, so I will speak Hebrew. And also, I hope you translate each other. Thank you, sorry. תרשו לי להתחיל בסיפור אישי שהוא המוטיבציה שלי לכתוב את העבודת מחקר הזו. לפני שנתיים ליוויתי את הבן שלי בחודשים האחרונים של החיים שלו, והוא היה חולה בלוקמיה, ובשלב שלא היה עוד כבר אפשרות לטפל, אז הרופאים ניגשו אליו. הוא בן 17, לפי סעיף 2 לחוק החולה הנוטה למות. בגיל 17 ילד אמור לתת הנחיות מקדימות של סוף חיים, אם הוא רוצה להמשיך בטיפולים או בעצם לתת למחלה לסיים את העבודה שלה. הבן שלי בחור חרדי עם הרבה גם סוג של חשדנות ביחס למערכת הרפואית שהיא לא דתית, אם הם יודעים, שומרים כמה הם יזרמו מבחינה הלכתית, והוא אומר בצורה נורא נחושה, ככה זוכרת אותו אומר את זה, כמה שיותר אני רוצה שישתמשו במכשיר החייאה גם בשביל שאני אחיה עוד דקה אחת, גם אם יש בה המון סבל. ואני אימא שלו לידו. קצת לפני הפטירה הרופא קורא לי ואומר לי, תראי, הוא אמר את העמדה שלו והוא בן 17, אנחנו צריכים ללכת לפי מה שהוא אומר. רק שתדעי שמכונת ההחייאה גם יכולה לקצר חיים. ואז פתאום הבנתי שזה לא רק שאלה של דת מול רפואה, אלא שאלה הלכתית אם יש מותר להשתמש משהו שמקצר חיים, ואנחנו מעלים את הרב על הקו ואת הסבא על הקו ומתחיל דיון. למחרת הוא הלך לעולמו, והשאלה של ההחייאה גם אפילו לא עלתה. ושאלת המחקר שלי בעקבות התקופה הלא פשוטה הזאת זה איך ילדים חולים במחלות כרוניות ומסכנות חיים מאוכלוסייה חרדית תופסים את ההשתתפות שלהם בקבלת החלטות שקשורות לבריאות שלהם, לא רק החלטות כל כך כבדות, גם החלטות שהן יותר פשוטות. הבסיס התיאורטי שאני מדברת עליו הוא המודל האקולוגי של ברונפנברנר, לפי הניתוח שטלי גל עשתה איתו, שבודק את הזכות להשתתפות של ילד בכל מערכות החיים, מעגלי החיים שמקיפים אותו. ילד נמצא במרכז, הילד מקבל החלטות בהתאם לגיל, למגדר, לתכונות, לאופי שלו, אבל הוא לא עושה את זה לבד. יש במיקרוסיסטם המערכות שסביבו שמאוד קרובות לה בקשר ישיר איתו, שזה ההורים שלו, אחים, בית ספר, חברים קרובים, הם איתו בקבלת ההחלטות, ולא רק שהם מולו, אלא גם כשהם ביניהם, למשל כשההורים מדברים עם בית הספר, בית הספר החברים הקרובים, בקשר לילד, זה מעגל שאנחנו קוראים לו המזוסיסטם, משפיעים על האמצעים והדרכים של לקבל החלטות, לקבל אינפורמציה, לתת אינפורמציה, לתת משקל לעמדה של הילד. באקזוסיסטם, במערכות שלא יוצרות קשר ישיר עם הילד, יש למעשה את כל הגופים האחרים שנמצאים בקשר עם מערכות המיקרו, למשל מקום העבודה של ההורים. זה משפיע בסופו של דבר על הילד, בהיבטים כלכליים, בהיבטים חברתיים, קהילה, שכנים, תושבי ישראל, כשזה רלוונטי, גופי תרבות, חינוך, זה מעגל האקזוסיסטם. סביב כל אלו יש את מעגל המקרוסיסטם, שזה שחקנים לא אנושיים, בדרך כלל זה החוק, ההלכה, התרבות, הנורמות, הם כולם ביחד מעצבים את ההשתתפות של הילדים. לצורך הרעיון שלי אני דיברתי עם ילדים חולים, קבוצת הילדים החולים, ההורים של הילדים, מדאיגים בקהילה, גורמים קהילתיים וגורמים מקצועיים מחוץ לקהילה. אני יוצאת מנקודת הנחה שאנחנו יודעים על קהילה חרדית, אנחנו יודעים על מה מדובר. אני כן אדבר על שני מאפיינים בולטים, זה שרלוונטיים להשתתפות של ילדים חרדים חולים. מאפיין אחד שהוא מאוד חזק, שזה המאמץ להתבדל מהחברה הכללית. זאת יש כתיבה על זה לא מעט, זה הרצון לייצר תרבות מובלעת בתוך חברה מודרנית שהיא דוברת את השפה, משתייכת לאותו עם, שזה מאוד מאתגר. זה גם ההסתייגות מטכנולוגיות ואינטרנט, לא בקטע של טכנולוגיה בפני עצמה, אלא טכנולוגיות שבעצם חושפות לערכים ונורמות שרוצים לשמור מהם. זה מאוד משפיע על ילדים חולים ברגע שאנחנו מגבילים את האינפורמציה שהם יכולים לתת ולקבל. המאפיין הנוסף זה סיפור השידוכים. נישואים בחברה החרדית כוללים הרבה ברורים לפני, ואנחנו רואים שכשיש הנושא של שידוכי בריאות מאוד רלוונטי בקהילה החרדית, ולכן ילד חולה ידבר, יקבל החלטות, ישאל, יספר, ישמע בהתאם לסיפור השידוכי. ומה שבלט, ואנחנו עוסקים פה במשבר, אני לא מתעסקת כרגע במשבר המדינתי, אני מתייחסת למשבר ספציפי שילד חולה, אבל מה שאני ראיתי, אני חושבת, דבר שנראה לי שהוא קיים בכל סוג של משבר, שקורית תופעה מעניינת של ערעור של המערכת האקולוגית. אנחנו רואים דמויות שנמצאות במעגל המיקרו, שהכרנו אותן נורא קרובות לילד, פתאום נדחקות החוצה, ובולט עוד יותר זה דמויות ממעגל האקזוסיסטם, שנכנסות פנימה להיות חלק מהעולם של הילד, וזה סופר מאתגר בחברה שהיא רוצה לבדל ולהישמר מכל מיני מערכות של אקזו. זה מאוד מאוד מאתגר. אני ככה אדגים את זה במה שקורה במעגלים האקולוגיים, ואחר כך אני אציג כמה דמויות שמשנות תפקיד ונראה מה קורה בהיבטים האלו. אז יש לנו את המיקרוסיסטם, ההורים במיקרוסיסטם שילד חולה חזק מאוד, הרבה יותר מילד בריא. אני זוכרת גם עם עצמי איזה קילומטרז' של שעות שההורה נמצא ליד הילד, ואומרת לי ילדה, ההורים שלי דיברו במקומי, האכילו אותי, אכלו במקומי, חיבור מאוד חזק של מערכת מיקרו. שימו לב כמה זה מצביע על השתתפות לפה ולשם, כי ההורים למעשה ממלאים את התפקיד שלו, אבל ההורים גם ממלאים חלק של לשתף אותו ולהביא אותו לקבלת החלטות ושותפות במחלה שלו, כמו אותה אימא שלימדה את הילד שלה בגיל מאוד קטן לבדוק סוכר, לדבר עם הרב, עם המלמד בכיתה שהוא צריך ללכת הביתה כי הסוכר גבוה. הדברים האלו נמצאים במערכת המיקרו. המזוסיסטם זה יחסי גומלין בין הדמויות שקשורות לילד, שהילד לא שותף בהם, אבל ההשתתפות שלו מושפעת. לדוגמה, מספרת לי שולי, בחורה חולה, שאימא שלה אומרת לאח שלה, כשאח שלה יתרס, אל תגיד לבחורה שהיא חולה. כי זה שידוכים וזה מורכב ולא רוצים שזה יצא החוצה. כמה זה משפיע על מה היא יכולה לדבר ומה לא בתחום המשפחה. מצד שני יש לי את אותה אימא שישבה ודיברה עם הרופאים, והיא דווקא כן הילד לא רצה לדבר בכלל על המחלה שלו, זה היה ילד שכל הזמן רצה לברוח מהמחלה, והיא שמה אותו בשטח כדי שהוא ישמע והוא לפחות ייקח חלק בהקשבה, גם סוג של השתתפות. מעגל האקזו התגר אותי אפילו למצוא ממצאים, כי המעגל האקזו מאוד התבלבל. יש הרבה דמויות אקזו שנכנסו פנימה, ומאלה שנשארו בחוץ יש שתי קצוות מעניינים. קצה אחד זה הרבנים, שמאוד מעורבים בטיפול במצב של מחלה בחברה החרדית. הם מייעצים, שואלים אותם, כמעט אף פעם הם לא דברים עם הילד. אמר לי אחד הרבנים שראיינתי, הוא אמר לי חבל, פעם היו שולחים את הילד עם התרנגולת לרב, היום מדברים רק דרך הורים. אני לא יודעת, יכול להיות שזה גם משמר איזושהי מערכת אקולוגית בצורה הזאת. רב אחד, כן, יש לו ילד סוכרתי, אז הוא מדבר עם ילדים סוכרת בעצמם, אבל הוא אמר לי זה נדיר, זה רק אני כך, זה לא כל כך קורה. והרב אומר כן, ההורים אומרים כן. מנגד נמצאת הקבוצה השנייה, שזה ילדים מהציבור הלא דתי, שלכאורה היו יכולים להיות קבוצת שווים, פוגשים אותם בבית חולים, זה החיבור מאוד מאוד טבעי, ויש ממש חלוקה אין קשר, ההורים ידברו ביניהם, הילדים לא ידברו ביניהם. שוב סוג של השתתפות. במעגל המקרו אנחנו הבאתי דוגמה של רופא שאומר לילדה, הקדוש ברוך הוא אלוקים בחר אותך שאת תשלטי בסוכרת שלך ולא הלבלב, והילדה בזכות זה יוצרת קשר עם הרופא. זה איזשהו שימוש בערכים שאפשר לה לקחת חלק ולהשתתף. וילד אחד, ומה זה חמוד, אמרתי לו, איך נראה לך ילדים יותר צריכים להשתתף, יותר יעזור שילדים ישתתפו ויקבלו החלטות וכולי. הוא אמר לי, מה זאת אומרת? צריך לעשות חוק הקשב לילד. כמה דמויות שנכנסו פנימה, זה הרופאים הכי בולט. הרופאים נכנסים פנימה, הם קרובים מאוד לילד, יותר מההורים והמשפחה, ואז יש לנו את יהודית אומרת לי שחברה שלה מספרת לה על איזשהו רופא שהיה מאוד נחמד, שהוא מסכן את הילד מבחינה רוחנית, כי הוא מדי נחמד והוא חילוני, שהיא תיזהר מחיבור בין הילד לרופא. וזה סיפור לא מאוד מצוי, אבל זה מצביע על משהו. אנחנו רואים עוד קבוצה שנכנסת פנימה, זה הארגונים הקהילתיים שאין להם מגע ישיר, מצב של מחלה, בגלל האתגר של המחלה, לפעמים אפילו מתווכים בין ההורה לילד, מסבירים את המחלה כמו אותו פעיל שהסביר לילד מה יהיה לו בנשירת שיער, שזה מצביע על החלמה ולא מצביע על חולי, ואז הילד אומר, טוב אמא אני לא צריך פאה. זה לדעתי חלק תפקיד מאוד חשוב ומשמעותי ששווה להכיר. יש מערכת שנדחקת החוצה, לא תמיד, לא בכל מקרה, מערכת החינוכית. וזה מאוד חשוב שזה ילדים חרדים, כי המערכת החינוכית היא גם משמעותית מבחינת השימור שלהם בתוך התרבות. וזה גם שזה שאי אפשר להשתמש לפעמים בטכנולוגיה ובזום כדי לחבר את הילד לכיתה, גורם למצב שיש עוד יותר ניתוק וזה מאוד מאתגר. אני ממש עוד אותו מסיימת. יש שתי קטגוריות של תגובה שיכלתי לתת עליהן את הדעת. יש תגובה לאותו ערעור של המערכת האקולוגית. ראיתי שתי סוגים של תגובה. תגובה אחת שהיא כאילו גמישה. אותה אימא שהילד שלה קיבל אייפוד, היא לא הייתה נותנת אייפוד לילד בשגרה, ואמרה הילד כבר חולה, יש לו אייפוד, אני לא, שימשיך לשחק בזה. אולי הורים אחרים היו עושים אחרת, כן? ולעומת זאת, סיפור גם די קיצוני, אבל הוא שוב מצביע על משפחה מסוימת של תגובות, אבא שממשיך ללוות את הבן שלו לבית חולים כל פעם, למרות שהבן כבר התחתן והוא אבא לתינוקת, לא בגלל שהוא דואג למצב הרפואי שלו, אלא בגלל שהוא דואג למצב הרוחני שלו, שהוא לא יתקלקל. הדבר הזה, אני חושבת שמבחינת, שאנחנו מדברים על מחוסר תקווה לתקווה, שאנחנו חושבים על מדיניות שאפשר לקדם כהשלכה מהמחקרים, אני חושבת שיש מקום שבאמת כל חקיקה, עבודה, קידום של מנהלים, צריכה לתת את הדעת על מיעוטים תרבותיים, על ילדים מיעוטים תרבותיים, על הסביבה שלהם, על המסגרת האקולוגית. מבחינת מדיניות, כמובן שכל הסיפור של רגישות תרבותית, מדברים על זה הרבה, אבל אני חושבת שגם ההבנה שילד הוא חלק ממעגל שלם של משפחה, של מערכת חינוך, אצל כלל הילדים ובקבוצות תרבותיות זה כל כך חזק והערעור כל כך מפחיד, צריך לתת על זה את הדעת. מבחינה מחקרית צריך להיות לדעתי ערנים לסיפור של המשבר בעוד מצבים משברים. אני חושבת שזה קורה בהרבה משברים חברתיים, משברים שקשורים לילדים, שיש ערעור של מעגל אקולוגי וכניסה של דמויות חיצוניות פנימה, ושווה לתת על זה את הדעת במחקרי המשך. גם מבחינה טיפולית, הערנות להורים המגמישים וההורים המשמרים, וזה יכול להיות אותה אימא, אני גם הייתי אימא לפעמים מאפשרת ולפעמים שומרת, להכיר את זה ולתת את זה את המקום ולתת תקווה לילדים שישתתפו יותר בבריאות שלהם. תודה.
Okay, good afternoon everybody. First of all, thank you to all the organisers of this fascinating conference. there is no doubt that being abducted by a parent to another country is a time of crisis for a child. Today I will be talking about the participation rights of abducted children in legal proceedings which take place following such an abduction. Okay, and this is roughly what I'm going to talk about. First of all, I'm going to very briefly explain the legal framework of those legal proceedings under what is known as the Hague Convention, a little bit on how children's views are ascertained in those proceedings, and then about one of the exceptions, which I'll explain in a minute, related to the child's objection, and then some very preliminary findings from an empirical research project which I am doing, and finally, I hope I have time, a real live example from the case law where I happen to know what happened afterwards. Okay, so we'll start off with a legal framework where one parent wrongfully removes or retains a child under 16 in another country, a country other than the child's habitual residence. Then, if the left behind parent requests the return of the child, then under the Hague Child Abduction Convention, the state of refuge where the child now is obliged to return that child. Now today 102 states are party to this convention, so in very, very many cases the convention will apply. Now obviously these are legal proceedings concerning children, and we're used to child participation in all different types of legal proceedings, but the specific context of the abduction convention has an impact on the scope and methods of the child participation in a number of ways. Firstly, the convention provides a mandatory return mechanism. This isn't a best interests hearing like we're used to in custody cases. And it's also a summary proceeding. It's all supposed to happen as quickly as possible, so we don't have all the time to have reports from social workers, psychologists, etc. Usually, okay. And another problem is that very often judges see the proceedings as being a technical question of jurisdiction. In which case is the real best interest proceeding going to take place? Because the whole idea behind the convention, in theory, is that it's a first aid procedure. You send the child back to the place where he or she belongs, and then there they can decide what the child's best interest is. So this has an impact on how the child's participation is perceived in the actual abduction proceedings and themselves. Another issue is that because after the abduction, usually the child only has contact with the abducting parent, and that means that that parent is expected to have increased influence on the child, which obviously might also affect how one regards his or her participation. Okay, and the final point, which is very, very significant, is one of policy, because the rationale behind the Abduction Convention, in the eyes of many, is not simply a question of doing what is good for children, but also there's a deterrent. The idea is that if we immediately return children who are abducted, then that will deter other potential abductors. Also the idea of a sort of rule of law that the person who did a bad thing or abducted the child shouldn't get rewarded. And also the concept that the actual real dispute should take place in the convenient forum. Okay, now, of course, from a child perspective, child-centered perspective, there's, of course, a problem with those issues. First of all, because even if the child is returned, it doesn't necessarily mean that there will actually be any further proceedings. So he mightn't get an opportunity to participate in the future. And, of course, the actual return, even if it's only meant to be until the court there decides, that itself has a very real impact on the child's life, or often irreversible. Okay, so that's the legal framework. Okay, now there are a number of exceptions to this mandatory return mechanism, and 3 of those are child-centric. One is grave risk of harm. Another, the child is settled in his new environment, but only when already 12 months has passed since the abduction before the return request is filed, which of course is pretty rare because most left behind parents don't wait 12 months. And then there's what we're going to be focusing on today, the child objection exception, which is clearly most significant when we're talking about child's participation rights. Okay, so that's what we're going to be talking about. That's Article 13.2 of the Convention. The judicial or administrative authority may also refuse to order the return of the child if it finds that the child objects to being returned and has attained an age and degree of maturity at which it is appropriate to take account of its views. I should say, I hate saying its views as a child, but that's what it says in the Convention. I should say his or her. Okay, maybe just very briefly to compare it with what we all know, the Child's Rights Convention, which of course was 9 years later. There are, of course, some similarities. Both talk about the weight of the child's views according to age and maturity. But obviously a real difference is that the Abduction Convention doesn't say anything about how we are going to find out what those child's views are. Whereas, of course, the CRC does say that the child has a right to be heard. What sort of hearing is another issue, but that's that. Okay, so what happens in practice is that each state decides how child's views are ascertained. The Hague Convention itself doesn't have any provision about how you find out whether a child objects. Each state decides, and there are quite a lot of research that's been done on this. There are wide variations between different jurisdictions. There are basically three main ways of hearing children: indirect hearing, direct hearing, or separate representation. Because of shortage of time, I'm not going to go into the pros and cons of those. They're very well also documented in the literature. Just to make two brief points. One is that today, many scholars and others take the view that in order to ensure that the child's participation is effective and that their views are conveyed fully and accurately, there is a need to have more than one of those types of hearing, what's referred to as a blend of approaches. The second is whichever method of hearing one adopts, it's essential to ensure that children are provided in advance with the necessary information and explanations in a manner appropriate to their age. Specifically, they have to understand what are the limits of the Hague Convention. And without that information, then their views may be based on misconceptions, which substantially undermine the value of participation. And if we get to it in the example at the end, we'll see, I think, a real example of that, where the children didn't really understand the consequences, what would happen if they were returned. Now, perusal of the case law from a variety of jurisdictions show that there are four main issues in relation to which there are differing approaches in different jurisdictions, and even between judges in the same jurisdiction, in relation to how they implement this child objection exception. Okay, that's the exception that says if the child's old enough, then the court can refuse to return the child when the child objects. And these four issues are age and maturity, independence of views, strength of views, and the policy of the convention. So I'll just say a few words about each of those. Age and maturity, no consistency between different judges and courts. There's cases where children of 6 have been held to be old enough, and other cases where teenagers are held not to be sufficiently mature. Okay, the average age globally is 9.8. May well depend on the personal views of a judge or expert. Some experts, one expert said children under 15 can't really understand. Others, of course, refer to parental alienation syndrome. Okay, I'm going to fly through this to get to the statistics, otherwise I won't get to them. Differing approaches to independence of views. Some assume that the views expressed by abducted children are the product of influence by their parents, and therefore don't pay any attention to them. It's really not at all consistent with the ecological system which we just heard now. Others take a view that influence by parents isn't inevitable, that all that matters is whether it's undue the influence. Strength of views I'm going to skip. and also differing approaches to the policy of the convention. Again, I'm put it on the screen if you can read it very quickly, but due to shortage of time, I'm not going to actually read out what it says there. Okay, so now I want to, in the few minutes left to me, talk a little bit about a research project which I started a year ago. The idea of this project is to provide a deeper, more accurate and widespread information about how the convention works. Israel is used as a case study, but I believe that our findings will also cast light on what happens in other countries. There's 3 stages. The first is analysing judicial decisions. The second, which we will get to, I hope, next year, is to distribute questionnaires to parents who were involved in abductions and their children, now adult, not minors, and also some questionnaires. Okay, now just very briefly, some of the where are we now? So far, we have done quantitative analysis of all the decisions which have been reported in Israel, and some unreported decisions. We've asked judges to send us unreported decisions. We've received some. I'm going to send some reminders out, and I hope we'll get more. Okay, to date, this is since 1992 when the convention came into force, 1993. To date, we've had 147 cases, of which the mother was the abducting parent in 75% of them, and the father in 24%. The one other case was a very well-known case of the grandfather who abducted his child and the parents who were killed in the cable car disaster. So that's the amount of figures we're talking about. We looked at the age of those children, and we saw that around half the cases is of child of 6 years or older. Because if we're talking about participation, then most people take the view that under 6 is less relevant, at least. So that's the sort of numbers we're talking about. Methods of hearing the children. We saw that, so we're talking about out of 99 cases, the children were directing the judge in 23 cases, and by a social worker in 1 case. There was a social work report in 32 cases. An expert was appointed in 37 cases. Child was separately represented in 5 cases, of which 4 were in the last 2 years. That's where there's been a real change. And you can see that in many of the cases, or some of the cases at least over 20, about 20 of the cases, then there was more than 1 form of hearing. Now, what about the outcome? The child abduction exception was actually claimed in 39 cases. Out of those, which really isn't very many. I was surprised. I thought it would have been more than that, but that's what our statistics show. And it was accepted in a third of them. I've looked very briefly at the global statistics available. I won't go into it now, but my initial analysis is that's low. That in abroad, it's accepted in more cases. After appeal, it was even less, and only 11 cases was the child not returned because of the exception. And what's interesting is that in the 11 cases where return was refused, only in 4 of them was it the child objections was the only reason. Okay, in the other 7, the court also thought that the grave risk exception applied, which suggests that it's much easier for judges to listen to children's views if they accord with their own views. There's a grave risk. Okay, so we'll say the child's right. But in other cases where it isn't so obvious to the judge that the child will be harmed by being returned, then they don't listen to their views. The age is the mean age was 11.3, which is higher than the global average. Reasons. Many cases, more than 1 reason were given. The most common reason was the child's views were not independent. And just half a minute on this example case, a case involving children aged 13, 11 and 9 who were retained in Israel by their Canadian mother. In the first instance court, the judge met the children, decided that while the oldest is mature enough, 13, she's a mouthpiece for her mother. This was on the basis of a 15, 20-minute interview. ordered return. The mother appealed. Okay, I don't know why it doesn't show that, but on the left side it's the district court, the right side it's the Supreme Court, somehow it got made smaller. The district court, the majority said that it wasn't sufficient for the judge to have spoken to the children, and there had to be an expert report. Thought the judge's impression of the lack of authenticity of the oldest child Jews was problematic, and the children should have received separate representation. And what's significant here is that those children, when they spoke to the judge, were not told that if they went back to Canada, their mother would not go back with them because there were criminal proceedings and she'd be told she'd be put in jail. So anything they said to the judge was not meaningful because they simply didn't know that. So the district court said you should have go back, have an expert report. The father appealed to the Supreme Court, who said, don't need an expert report, you have to go back straight away. Their children did go back. There was a scene at the airport. They did go back, but question mark, happy ending. After 2 years, the father, it seems the children really, you could see they must have made his life difficult there. The mother said they suffered a lot. After 2 years, the father agreed that the children could come back to Israel. All because it seems the judge did not take their view seriously. Summary, I'm not going to say it out. Later stage of the project will hopefully shed further light on the long-term effect of inadequate participation of children, and I hope I may be able to present some of the findings at future conferences.
Thank you.
Okay.
Hi, and thank you for this opportunity. As you can see by the logos, maybe I'm in transition. I used to work many years for the Disability Rights Clinic in Bar-Ilan University, Faculty of Law, and now I moved to Tel Aviv University, where we're constructing a disability center for the whole university, which is very new and exciting. Also, 2 months ago, I submitted my PhD thesis, which was under the supervision. Thank you. Really. It was a journey, like you all know, under the supervision of Michal Alberstein and Gideon Sapir in Bar-Ilan. And it combines dispute resolution theories with disability rights, and it is very much based on my experience as a practicing lawyer. So what I'm going to represent to you today is the third article of my dissertation. It's an article's dissertation, and it has my dissertation. I will just say it very briefly. I took dispute resolution theory, which is called DSD, which I will explain later a little bit about it, and combine it with disability rights. And the third article applies this system on child welfare. And this is also with the very good advice of Tali Gal, which I also would like to thank right now. So, I move it like this, or? Okay. So, child welfare and disability. When we talk about child welfare and disability and the disability of the parents, we can think of different aspects of difficulties. There is a difficulty conceiving children, sometimes physical problems, nurturing young children, and also psychological challenges raising children. And my research focuses mainly on these types of psychological difficulties, because in my view, also as a practicing lawyer, these are the challenges that are most challenging in the intersection of disability and parenthood in child welfare proceedings. So let me briefly try to elaborate on these difficulties by telling you about my two customers, Sam and Ella. I will not tell you the whole story because it will be very interesting, but it will take an hour. And but this is actually the case that brought me to start investigating this field. So Sam and Ella has some kind of mental disability. Sam is not diagnosed. They have a baby. After 1 month, the baby is is taken away from them because of a certain incident, but he's returned to them after one day. They hire a lawyer, they pay her a lot of money, and the child returns to them. But ever since then, they're under the eye of the welfare system. And this is when they approach me, because they couldn't afford the private lawyer, and so they turn to the clinic. And I start to represent them, and they're actually doing quite well. They're very they care a lot about their child. They have some technical problems. Sometimes they forget appointments, but there's no, at that point there is no question about their ability and the way that they care about their baby boy. But as the boy grows older, things are getting more complicated, and they're missing appointments, and there are already concerns about his developmental states, and at this point, Ella's grandmother dies, and it appears that they had a very special connection, and Ella returns back to being anorexic, and Sam is immersed with hair care, and really the state is getting worse and worse. And even when I initiate a meeting with the welfare, the welfare, their social worker tells me, I'm now focusing on the child, because I can't talk about the mother. I'm now focusing on the child. Of course, this is not a typical social worker. I have a lot of respect to social workers, and but she was very young. I think maybe I can say it for her. And this is what she says. She's really totally separating them, and the situation grows worse and worse. The end is very tragic. The child is placed in his grandmother's house, and after a month, the grandmother dies of cancer. It's really like a Greek tragedy, and the child is taken to foster care, and the parents agree. And I please don't quote me. I hope this is not filmed, but I'm also very much relieved, and what I felt. Wait, how did we go back? What I felt mostly in this case, and this is just a typical case, and a very tragic one, but not unsimilar to others, is that when I go to court as a lawyer, there are some problems that keep occurring. And what we see, and not only in my case, but also we see it in the literature, that parents with disabilities and parents from underprivileged groups are repeating players in this courtroom of here it's a juvenile court in the States. There are like many kinds of courts, family courts, youth courts. So we see this many times. We see the same players. There is a choice between tragedies paradigm. It's like it's a tragedy if we take the children away, and it's a tragedy if they stay at home. So this makes everybody's work much harder. Also, very interesting. There's no place for disability discourse in the courtroom, because I'm a disability rights advocate, and even I know about and I will tell you a little bit about it. There are disability rights. There are parenting disability rights, but in the courtroom, I found myself silent about these rights, because I knew the courtroom is a place. It's children's rights, a courtroom, and usually the court's view, at least as I experience, is that it is adversarial. It's parents against children rights, and when a parent has a disability, this is usually translated against the children as something that is not good for the children. And also something very, very important is that the court focuses on parenting as functional care, and therefore sees what the parents do and what the parents don't do. And usually there is a correlation between the disability and a dysfunctional parenting as viewed by the court. So this was my experience, and not only mine. And then my suggestion solution is based on the very important saying. I don't know if you can see it. It's not me, it's the system. Okay, it's not because I found myself helpless, but I decided after some years that it's not about me, and that the system should be changed. So what I'm suggesting in my thesis is to redesign the child welfare system according to dispute system design based on disability rights principles. So what does it mean? So my research has 3 pillars. The first one is disability rights. I can't. It's like it's a whole course. It takes a year to learn. But usually, when we talk about disability, we talk about all kinds of disabilities. We view disability not as an inherent and organic feature, but as an outcome of a social construction. The most trivial example is that the stairs. If a person uses a wheelchair, they cannot go into the conference room, not because they use a wheelchair, but because there are 3 stairs there, and if there was a ramp, they could make it to anywhere. And therefore, our aim as society is to remove barriers, and we also have an international a treaty, the Convention on the Rights of People with Disabilities, and there is a special article about the respect for home and family. So they do talk about obstacles that are very inherent to home and family. Dispute system design is a dispute resolution theory. It's a very advanced one. It consists of 6 elements, which are what it basically says is when you want to design a system and to make it to make the best of trying to manage and resolve disputes, you have to design the system according to the goals, to the stakeholders, to the context and culture, process and structure, researchers, and you have to measure successfulness. It's very trivial, but they're the first ones who actually put it together. And it makes a lot of sense. And what I'm trying to do is to apply to the child protection system. So what I'm actually talking is about a ramp to family life. And I'm asking what is the ramp for family life using this combined theory. So when we talk about goals, we have to think about disability rights as one of our goals in child protection system. And I think first and foremost, we have to transform the negative perceptions of parents with disabilities according to real studies and evidence about parenting with disabilities, which also has positive ramifications. And we have to put a lot of emphasis on preventive and proactive solutions before the judicial intervention. If we know there are some problems that are going to occur, we can deal with them beforehand. We can actually provide the ramps for the parents before something happens that can lead to negative implications. Also, we're talking about universal access to justice for children and parents. About creating universal solutions that will help, like daycare or like longer daycare, so that everybody can use the system, and support systems. When we talk about stakeholders, a very important theme is nothing about us without us. We have to design the system with the parents with disabilities themselves. And another concept that is very important is interdependence. And I talk about 3 kinds of interdependence. First of all, the vision of parents and children's rights as inseparable, that it's not one against the other. We're talking about making the best for the whole family. We talk about, of course, we cannot talk about children's rights without the ecological approach. The interdependence, like Chaya also mentioned, and thank you, Tali, again for this, of parents with all the systems around them, and especially when we talk about people with disabilities, they share an interdependence with even more systems than other people do, like the people who help them, like support them, and their workplace, and schools, and their parents, and the family, and etc. And the last one, the last interdependence relationship is that I want us to think about is the interdependence between children and their parents, in the way that the parents are not only providing something for the children, providing care, but the children are also providing very important things for the parents. Even more so, I think if you are parents, at least I know from my parenthood that my children provide me with a lot of things, with identity, so on. And then when we think about parents and children, we should also think about that. Of course, there's 1 minute, so I will just briefly tell you that we also have to consider context and culture. This has to do also with culture sensitivity that doesn't only have to do with disability, but with other cultures. We are and not be judgmental, just according to, be humble about what we think about best interest of the child is. Process and structure, we talk about, of course, accessibility. We talk about multiple dispute resolution options that we should consider, mediation, family conferences, procedural justice focus, which is very important. Many parents say that they feel that they are not heard or they cannot enter the courtroom. Therapeutic jurisprudence is a whole topic. I will talk about it later from whoever is interested. Of course, resources are very important. We first have to legitimize the cost. We have to say that we do think that parenting with disabilities is important, and then we will be able to allocate the funds to family support. And finally, we have to measure our success. I'm finishing. I'm not going to show you my qualitative research, but just I want to say that I interviewed parents and children, and not the children. I didn't interview the children, but the parents and their lawyers and guardian and citizen and judges. And I was kind of combining. For example, here I show what they said about success, and trying to find out what the system should look like using the people that actually are using the system. So thank you.
So let's have the speakers back here, and we have time for like 1 or 2 questions tops. So
I would like to ask a question. There is one word missing here throughout the excellent presentations, which is child's happiness. Is the child happier? Now I know that there are many lawyers here looking to rights. I'm a social worker, and I want the child to be happy. Thank you.
any other questions? So I'll do one for the entire panel. So I wrote a lot of notes while you were speaking, but I think my common question to all of you is about money. This country is going through a war. There's a problem with taxation. There's a problem with service, whatever. We have no money. And everything you say is wonderful. It's lovely. In the perfect world, I would like to have everything. But in a country that wants to desegregate the Haredi population, for example, paying for it to keep being segregated is not something that's going to happen. In a country that doesn't have enough for health, there isn't enough to pay for better social work, etc. So how do we work in reality? How do we take all of this? So give me some hope, please. Take this to reality. And it's for all of you, so whoever wants to take it, be my guest.
I have the solution
Yeah.
for your problems.
For all my problems.
No,
Okay.
for one problem.
Okay.
Because I think that, well, at least from my perspective, talking about asylum-seeking children and the asylum-seeking community in general, I think that the problem is not money. I think that if we would have looked at this issue of forced migration as an economic opportunity, we would have dealt with this issue completely different. Instead of wasting so much money on deportations, instead of wasting so much money on restrictions of the society that is here, communities that are here, instead of wasting so much money of bringing people from outside the country to work in Israel as foreign workers, we could have dealt with this completely different if we were interested in money. But actually, it seems that there are things which are more important than money.
I agree.
I don't know. My personal vision is 2 points. Firstly, if somebody wants to do something, usually he or she finds a way to get money. And secondly, in the area of my interest, I think volunteers and NGO can do incredibly a lot. Thank you.
חיה, את יכולה בעברית אם את מעדיפה.
תודה. הכי קל לנו להגיד על כל דבר, נביא מלא כסף, נעשה הכשרות, נעשה התאמות. דווקא המושב הזה מראה שזה לא כסף. לראות ילדים פליטים, לראות ילדים דוברי שפה אחרת, לראות הורים עם מוגבלות, לראות ילדים חולים. החוק לא רואה אותם בכלל. חוק זכויות החולה לא מזכיר בכלל ילדים. בואו קודם כל נהיה ערים לקיומם של ילדים. אחר כך נחפש את הכסף.
In the field of my research, I don't think money's a real issue. It's more the question mainly of judges and also sometimes of experts of taking children's views more seriously, being less paternalistic. And I think in the case of abduction, I think it's actually understanding better what the intention of the drafters of the convention were. Okay.
Children's rights seriously.
I first of all, I agree with what was said before about how we can actually save money by thinking of things before and not just putting down fires. But like I said about in my resources slide, I think it's a matter of where you put what you care about. If you legitimize something, then you would also find the means to promote it.
Thank you. Okay, coffee.